please open court.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Be seated.
Good afternoon to everyone, and welcome to the Tennessee Court of Appeals. Are there any preliminary matters, Ms. Clerk?
I was about to say, our attorney wasn't here, but he just made it. There are no preliminary matters.
Actually, the attorney that's going to be arguing the case he's from out of town and he's parking his car right now, Your Honor. If the court can indulge him for just a minute, he will be here shortly.
Okay. We will do that. Give him a minute or two. Are we all in play now?
We are, Your Honor. Thank you.
Thank you. Okay. Are there any other preliminary matters, Madam Clerk?
I do want to ask you, when I call this case, since they're all consolidated, do you want me to name off each?
Yes, when we call the cases, we're going to name all 5 cases.
Okay.
Now, before we start, there's an order that was sent out on January the 20th of last year regarding the timing of the case. Does any party have any problems with that at this point? The appellant would have a total of 20 minutes. You can divide that up any way you want to. 10 on front, 10 on back, or however you want to. The appellees will have a total of 20 minutes, and you can divide that up among yourself. Okay. Now, I only see 3 attorneys for the appellees. The 3 of y'all have all control of all 4 cases. Is that correct? Okay. And have you decided how you're going to divide your time and so forth, as far as who's going to argue?
Yes, sir.
Okay. Then the appellant, have you decided how you're going to divide your time? Who's going to argue first, and you'll be doing the full argument?
Yes, sir.
Okay. And how do you want your time divided?
I would take 15 minutes and then reserve 5.
Okay, then. If there's no further preliminary matters, Madam Clerk, will you please call these cases?
Erika Jean Schanzenbach versus Cheryl Hanzlik. Erika Jean Schanzenbach versus Althea Skeen. Erika Jean Schanzenbach versus Denise Skeen. And Erika Jean Schanzenbach versus Rowan Skeen.
Thank you. For the appellant on all 4 cases, you prepared to present your case? Go right ahead.
Good afternoon. May it please the court. My name is Martin Cannon. I represent, along with Andy Fox, Erika Schanzenbach. She's the petitioner in all 4 cases. My apologies to the court for running late. My GPS just took me to the wrong part of town. Now, the cases have been thoroughly briefed. I assume you've had a chance to look at those briefs. With respect to the facts, I will make no attempt here to recite them in any detail. They are laborious. They are beleagueringly set forth in the briefs. And
you do your argument, sir. You do your argument as you see fit.
Yes, yes. So, but while I'm going to skip over an effort to recite facts in detail, I do want to address an idea about the facts that I think skewed the analysis in the trial court. And that idea is that there was or is some kind of a legal or constitutional equivalence between the conduct of the parties here. 2 points on that. Erika, our client, when she's not running her small business, goes to the abortion clinic and stands on the public right-of-way along the roadside offering assistance, information, and sometimes opinion when she sees a person going in. She does it in a kind and peaceful and utterly legal manner. Very importantly, what she's doing is not only protected by the Constitution from the state, it is entitled by statute to be protected by the state. And I'm referring there to the half a dozen or so criminal statutes that the respondents routinely violate in their interactions with Erika. Now, all of that could be true also of the respondents, except for one thing. If our client were in front of the clinic, holding a sign, handing out a pamphlet, calling to a woman saying, "We can help you, let us help you, you don't have to do this," and if the respondents were standing next to her, calling to the very same woman saying, "Your body, your choice, go ahead and have your abortion," we would not be here. But the point that must be understood is that while our client is doing what she does, handing a pamphlet, calling out, holding a sign, the respondent's conduct is directed toward her. They unabashedly, overtly attempt to obstruct her message and intimidate her from expressing it. It cannot be overstated. There is no equivalence between the conduct here. These are not just people that have competing views on the sidewalk and they're doing the same thing and they just can't get along. This is not a he said, she said. It is a fundamental difference. She is expressing a message. They don't have a message for that woman. Their only effort is to obstruct hers. It is obnoxious. It, in many cases, constitutes assault and violation of other statutes. It is not protected. It is illegal. And one of those criminal statutes that we say they violate is the stalking statute, which makes it a crime and which provides the civil remedy that we are here to talk about. Secondly, very quickly, our client is not a protester. Her conduct is more akin to that of a poll worker. If you went to the polling place and you're walking up to it and a fella came up to you and said, vote for Charlie, here's why, here's a pamphlet, nobody would call him a protester. And nobody would tolerate it if some goon came along and pushed him out of the way, grabbed his pamphlet, put a bullhorn in his face, did everything they could to interfere with that engagement he's about to have with you. If he wanted a protection order, he would get one. Just like if you were going to the grocery store and every time you showed up to the grocery store, some guy came across the parking lot, stepped on your feet, put a bullhorn in your face, licked you, pushed his body against yours, any number of things, you'd get a protection order. The fact that the abortion issue is involved here is a red herring. So
I'm going to interrupt you briefly and sort of skip forward to what to me is one of the more challenging aspects of your claim, and that's the requirement for the criminal stalking statute that your client had to have suffered, I can't remember the exact verbiage, but some sort of mental distress, mental injury.
Right.
And in this case, the trial court, having heard her testimony, concluded that she did not. So my question is two-part. What is our standard of review on that determination by the trial court? And number two, what evidence did you present for that element of the claim?
the standard of review is really you're looking for error by a preponderance of the evidence. It's not one I'm actually familiar with, being from out of town, but my understanding is that you can reverse, even though there's some level of deference to the trial court's findings of fact, you can reverse findings of fact if you find by a preponderance of the evidence that the evidence goes the other way. And of course, rulings, conclusions of law are entitled to no deference whatsoever. So if you look at, and it's kind of a de novo standard, if you look at the evidence yourselves and you find by preponderance of the evidence that Erika satisfied her burdens, you can overrule the fact findings of the trial court. And then going to the next question, the evidence of distress was manifold. I would point to, in the video, our Exhibit 5, at 5 minutes and 34 seconds, you see Erika holding a sign in a kind of a relaxed fashion, and as Alethea starts coming across the road to her, you just see her Erika's hands just tense up on her sign. She's anticipating, you know, the umpteenth episode of this engagement.
Does the mental stress component mean mental stress that you're suffering at the time of the alleged event, or does it contemplate subsequent mental stress as a result of the encounter?
The statute does not say. I would submit it could be mental stress at the time or later. We have on video at 21 minutes and 40 seconds of the primary video, we have Erika walking backward as she gets to her car because she's afraid to turn her back on Alethea. We have, and if you look at all the videos, by the way, the whole shebang is under an hour, and you really just need to watch them. There's no recitation of facts can do justice to what's going on here. At 39:30, Erika, who in every single other video is utterly unflappable, actually shrieks when Alethea reaches her hand into her car. The terror and fear and anxiety is palpable. And then we have her testimony. She testified that she felt threatened, that she felt anxious. On account of these fears, she adjusted the days and times during which she went to the clinic. She went home and drank beer, wine. She felt sick to her stomach. She suffered anxiety. She suffered sleeplessness. She had a problem concentrating the following day when she went back to work. The distress is we've seen a lot of cases, we've read a lot of cases about this. I'm not sure I've ever seen a case where the evidence of distress is more widespread and well established here. And
Do we have any cases, and I've read your brief, I'm sorry, I've read yours and everyone else's for this docket, so pardon me if I don't remember if you put it in there, but is there anything in your brief that deals specifically with Tennessee cases under this statute and what the requirement is to show the mental distress? Is there anything that provides a little more meat on the bones of the statute for us?
of Tennessee cases?
Yes.
I'm not recalling one
Okay.
as we stand here. I could be forgetting it though. But I think what you just need to do is look right at the language. I want to say the plain language of the statute, but the statute's a little tortuous. It's kind of a Rubik's Cube. Nonetheless, very importantly, it only requires that she establish one of the feelings that she's supposed to be protected from suffering. Just one. And a feeling of intimidation would be one. The emotional distress thing is actually related to the harassment statute definition, which finds its way into the statute. So she gets a protection order if she establishes harassment, which requires a showing of emotional distress, and I think we've satisfied that. And then she further gets her protection order when she establishes that she has experienced even only one of half a dozen or so different characteristics. I'm sure you've read that. Now, with respect to the facts, I'd love it if you just watch the video. It's painful, it's horrible, but I just love it if you watch it. I would have you focus your attention on the July 3rd, 2019 incident. You don't see what's going on directly, but you see it by way of a shadow. And this shadow is clear, it is creepy. Alfred Hitchcock could not have done a better job of producing this scene. Alethea has actually stepped around beside or behind Erika for the purpose of getting out from in front of her camera. And while she thinks she's out of view, she is asking her if I'm harassing you now or am I tormenting you now. Something is a little unclear, but then she says, how about now? And she reaches up and she blows in her ear. And then she steps back and does it another time or two. Like, how about now? How about now? You can see it with incredible clarity right on the video. And the shadow on the pavement helps you understand and correlate what she's saying to what she is doing. On August 14th, Erika's holding her sign, and like on many other occasions, Alethea comes up and drapes her entire arm over the sign, right in front of it, blocking the sign, putting her arm, bare arm, sweaty armpit, right over Alethea's hands. That's at 11:10 through 11:26 on the video. On October 2nd of 2019, at 23 minutes and 55 seconds on the video, Alethea actually licks Erika 3 times. Actually licks her. You don't see that specifically on the video because she's gone around behind or something. But when Erika says repeatedly, don't lick me, don't lick me, don't lick me, Alethea shrugs. Like, what are you going to do about it?
Is there anything in the record, and this may be beyond the scope of the record, but were there other criminal charges filed for assault or battery or anything like that?
There was one set. There's a little confusion because there were 2 criminal charges filed, but only one of those was for an action against Erika. Okay.
And if it's beyond the scope of this record, I mean, obviously I don't need to know that, but I wasn't.
The record that was discussed.
Okay.
And then with respect to intent to threaten and intimidate, Alethea has said all you have to do is go home. If you go home, I won't follow you. How about that? Stop coming to the clinic and this all ends. And then as she's tormenting and walking all the way to the car with Erika, step for step, right in her space, she says, this is what you have to look forward to every week, Erika, me. She says, take me to court or this is your life. She is plainly trying to intimidate Erika away from this perfectly peaceful, lawful conduct. With respect to the application of the statute, and I think I'm running low on time here, the judge got hung up on the domestic relations aspect of it, and he said he didn't feel like it really applied to these facts. The statute started off as a domestic relations statute and allowed a protection order for victims of domestic abuse. But the legislature later added both sexual assault and stalking as separate bases for a protection order, regardless of the relationship that was an element of the domestic abuse thing. Surrounding statutes reflect that change. In 363601, domestic abuse victim and stalking victim are defined separately. In 3917315H, very importantly, the statute says a stalking victim gets the same remedy here that we provide to a domestic abuse victim in the statute. So the statute by its own language is distinguishing and giving the protection to each of them.
Let me ask you this, and I know you're running low on time, partly because I keep interrupting you, but I know you're arguing each of the appellees together in terms of your argument for the appellant, but it seems to me like each of their conduct is different and varying in degree. So for purposes of our decision on this appeal, are we to consider each individual appellee and what they did and whether that meets the definition under the statute?
Yes.
Okay.
Yes. So I think finally, Your Honors, the important thing here is that when the judge said it doesn't apply to this situation, he's reading things into the statute or he's reading things out of the statute. The plain reading of the statute, following, harassing, you can't look at these facts and say they don't meet the language of the statute. And if you're going to say they meet it, but it doesn't apply, you're making something up. And I think that's what he did. He just got, I think, confused about maybe the constitutional issues that he perceived to be this equivalence. In fact, he did say these are like, competing fans of a ball game or something. That creates and assumes an equivalence that absolutely does not exist here. These are fundamentally different actors. So I don't know if I have any time left on the rebuttal.
Nope.
Okay.
You did? No, you don't.
Thank you.
Thank you. For the appellee. Will there be one argument or it's going to be divided up?
It's going to be one, Your Honor.
Okay, so you got 20 minutes then.
Good afternoon, Your Honors. I'm here on behalf of the four appellees, Alethea Skeen, Denise Skeen, Rowan Skeen, and Cheryl Hanzlik. I have a fairly fundamental disagreement with the idea that these appellees did not have a protected constitutional right to be where they were. And indeed, the trial judge made that determination. His 2 points were they had a right to be present and that both petitioner and respondents were exercising their free speech rights. The stalking statute explicitly carves out constitutional speech and behavior. And one of the arguments you'll see in the brief from the appellant is that they didn't have a message and that their message was to block Erika. The evidence that's submitted shows that that isn't accurate. For one thing, all of them are wearing shirts which say the word pro-choice. So at a minimum, there's visual evidence that they have a belief. What they're arguing for is that these patients, these women, who both sides feel passionately about, should not be subjected to harassment. The record shows that Erika, the appellant, was using amplified sound as well. She was making statements which reasonable people could find offensive. She'd been asked to cease and desist from certain behaviors, such as going into the road and from approaching the cars. The appellees believe that their role is to defend these patients' right to privacy. Bristol Women's Regional Center is not limited in its medical applications. It also performs a full range of gynecological services. So there's a belief that people should not be subjected to this type of conduct when they're seeking medical services, and that includes being told that they're murderers and that people are being killed.
So what conduct did your clients engage in that was protected in order to, that you allege was protected in order to protect the patient's privacy? What were they doing that was geared toward protecting the patient's privacy?
Sure. In the videos, what you will see is that there's a consistent reference to leave the patients alone, stop bothering the patients. It's admitted in the record that the appellant would go up to cars and try and pass pamphlets to people without knowing whether they wanted to receive that message or not. The signs that the appellant held could be disturbing, and their job, another detail is that appellant's amplified audio could be heard within the building, and that was disturbing to the patients in there.
So, assuming that, and I'm going to say Erika, not out of disrespect, but just so I don't have to pronounce the name and mispronounce it, but assuming that Erika is standing there doing whatever she's constitutionally allowed to do, when I look at that video and look at the evidence, am I going to see your client standing in front of Erika, standing beside Erika, using umbrellas? That's kind of what, from the part I've read, is the issue here, is not that your folks were there articulating a different viewpoint, but that they were there specifically to quiet the one side, and that the way they did it involved techniques that were intimidating and harassing, including what he's already said, which is the touching and the licking and use of umbrellas.
What I would say, Your Honor, is that the trial judge heard the testimony and saw the videos, which were extensive, and he did not make a determination on that basis that those things had been proven.
Okay, so did he specifically find that they weren't proven? And also, let me back up before you answer that. Did he correctly apply the statute in that there seems to be some language in the transcript where the trial court indicated that this because it was not a familial relationship, that it didn't fall under the order protection statute? Was that a finding that he made, and if so, was that correct?
His finding was based, by my reading, on three principal elements: that both parties had a right to be present, that both parties had a right to speech, and then crucially kind of the second element, which is that harassment's integral to the stalking statute. Harassment requires a suite of emotional states that are delineated by the statute. There is a case that we're aware of that is cited in our briefs. I believe it's State v. Flowers, which talks about the requirements in order to prove harassment. And one of the things in the statute is that it's both an objective and subjective test regarding emotional distress. It's phrased as a reasonable person to suffer that distress and actually causes a person to suffer that distress. And this is where I think the judge does deserve deference for having heard the live testimony. He concluded, I think, that the examples complained of, combined with the other facts on the record, meant that objectively and subjectively, Erika, the appellant, didn't have the required mental states. When you look through the transcript, you're going to see a fair amount of talk about anxiety as an emotional state, and about frustration, and less about the type of fear that is at issue. I think that refers back in a way to the reality that this was a situation in which these two people, or five people, were meeting at a place week after week after week. And one of the things that's discussed in the transcript is Erika thinking about the logistical burden. Will she have enough people with her? Will that satisfy, her needs? And those frustrations that the Skeens and Ms. Hanzlik posed to her aren't sufficient in of themselves. The other thing regarding the video is you will see both sides, and I apologize for making that equivalence, but you will see both sides engaging in what might be construed, and I think the judge construed as insincere descriptions about behavior. So, you licked me. It wasn't shown on the video. She says you licked me. In other instances, the respondents say, "You pushed me, you touched my body part." And that is a kind of consistent theme throughout. They're both performing for a camera. Or at least I think the judge could have concluded that from hearing the testimony and from watching the video. To continue, the application of the domestic violence statute, it is accurate that the stalking was added to the statute. However, the framework is still premised around domestic violence. So I think that one of the concerns that the trial judge had was that this was an extremely broad remedy for a discrete problem.
But you're not arguing that the stalking statute is limited to a domestic situation?
I'm not.
Okay.
No, I'm not arguing that, and I don't believe the judge made that determination. Instead, it's that the orders to protect the petitions saw that the respondents couldn't visit or approach the home or have any sort of contact with this person. It stipulated that they asked that their guns be taken away, and they asked that they be prevented from interfering with Miss Erika talking to women. So the penalty for violating order of protection can be arrest. So these are extremely serious requirements that could drown out and cancel out these people's ability to speak. Because who's to say where interference is? So it wasn't an appropriate tool, and indeed in the transcript there is discussion about it being too broad of a tool, because what they're really looking for was restrictions on conduct that are much more narrowly focused. And one of the judge's observations was that the domestic violence procedure wasn't really intended to solve this. Not because it's not a domestic relationship, but because of the competing interests and the fact that both parties were there week after week. Just to return briefly to the mental state aspect of this, the harassment is integral to stalking, and the judge didn't believe that you could get to stalking because of the nexus between the constitutionally protected activity, the right to be present, and the subjective and objective mental states, all of which I think are properly applied. Excuse me. Another element to note is that the standard for evidence against a trials court finding is a finding of fact with greater convincing evidence. So it's slightly more than preponderance from my understanding of the statute in Walker v. Sidney. Gilreath Associates from the Court of Appeals in 2000. The final element about why the order of protection statute's inappropriate is because this had been an ongoing issue for a significant period of time that was instigated by both sides. So it isn't accurate to say that the respondents were always initiating contact. There were instances in which, by her presence, the appellee initiated contact with her signs and with her speech. And that goes to this not being what the trial judge perceived to be regular stalking. He did use the analogy of a sports team, but I think it's more important than that because it does involve 2 people or 5 people's serious beliefs and sincerely held beliefs. And with that, I'm going to yield my time to Mr. Muse, my co-counsel, if that's acceptable.
It's acceptable. How much time does he have left, Ms. Clark?
7 minutes before we went to.
Okay.
Thank you, Your Honors.
Good afternoon, Your Honors. Devin Muse, just a couple points there building on this. Generally, the standard on a fact-based decision is a preponderance of the evidence, but key here is that the judge, as it relates to emotional distress, had to decipher credibility issues. Credibility issues are inherently tied to the factual question, and credibility issues on appeal, this court has to afford clear, it has to overcome a clear and convincing evidence standard. There's great deference that would be given to the trial court as it relates to any issues of credibility. This court will see that in Land v. Castile, 2011 case, it's Tennessee Appeals Lexus 112, and there will be multiple dynamics to that. And so that's important. And it's also important, as my co-counsel stated, that this court looked not only to the objective aspect of that emotional harm, and how practical and as a policy matter, a finding that certain constitutionally protected speech could still rise to offensive conduct would create a dichotomy that would not make sense from a policy perspective. For constitutional speech to also be inherently objectively offensive. But apart from that, and to the extent that certain conduct or speech may be framed as in not so constitutional grounds, we also have this subjective element around. The trial judge watched videos, heard testimony, saw all aspects at play, and had to credit credibility somewhere. And there was no rule that in the context of 20 allegations being disproven that the other, however many allegations are on the table, have to be bought. They can be blanketly, as a blanket matter, rejected on those grounds.
Let me
Interrupting counsel, what credibility determinations were made by the trial court?
Your Honor, the trial court judge did not credit Ms. Schanzenbach, the appellant's, in the least, subjective harm element. As my co-counsel noted, the trial judge looked. There's some shadows which don't prove much. He observed demeanors. He observed those, and he had to make a decision, and he observed the witness on the stand. He heard the witness's testimony, and in that, inherent in the judge's finding, is this emotional stress dynamic that speaks to the subjective harm claimed by the appellant. And one further note we would note for this court, although not briefed, this court does have an obligation, sua sponte, to consider issues of jurisdiction. That includes issues of justiciability. And so we would encourage this court, as it relates to that.
Is this an issue raised in your brief?
Your Honor, we are fine not submitting argument on it, but it is something that the court is obligated to consider sua sponte. That's issues of justiciability, and that is a valuable consideration for this court in this context. So absent any further questions on that.
Can you point out to the court what specific comments or speech that was made by your clients that are constitutionally protected?
Your Honor, there would be a number of speech, such as my co-counsel referenced, leave the patients alone, or the statements on their shirt, or, she has a constitutional right to tell someone that she doesn't like them here. She has a constitutional right to tell someone that, hey, if you're going to come here and yell at these patients, we're going to be here too. And she has a constitutional right to be there. And so generally, I think when this court, as it has done already, as it reviews the record and continues to review the record, it will find multiple instances of conduct that cannot be is not the equivalence of inciting violence, yelling fire in a theater when there is no fire. And in terms of any other speech that this court may find would not be constitutional, although we would submit there is generally all constitutional conduct, we still have that subjective element to deal with. The subjective element of if certain conduct actually offended or emotionally distressed the appellant to the degree, and whether the trial court was wrong in not crediting appellant in that regard. And again, That is a strong standard. There's a significant and substantial deference given to the trial court being there on the ground, if you will, able to observe all the witnesses, the evidence as a whole, and we know that this court will take that into consideration as it moves forward. So, absent any other questions from this court, we would yield.
I hear none.
Thank you, Your Honor.
That concludes the appellee's argument. Then we'll hear your rebuttal. We'll hear your rebuttal argument.
No, you have rebuttal. You used up your primary time.
Yeah,
You still got your rebuttal.
5 minutes to go.
The primary point I would make on rebuttal really is this. I think somebody mentioned that they're wearing a vest. They might say to Erika, quit talking to these patients. Those things are not why we're here. You can be violating a criminal code in a bunch of different ways, and you can be stalking a person, doing things that would entitle her to a protection order. And that's not obviated just because there might be a few protected statements that are sprinkled in. Take them all out. We're here about actions that are not protected conduct. They violate the law, they violate the statute, the stalking statute, and we feel that they entitle her to relief. Opposing counsel mentioned that the stalking statute has a carve-out for constitutionally protected conduct. Obviously, that's true. It's a complete red herring because we're not here talking about constitutionally protected conduct. He says that Erika would sometimes hand a person a pamphlet not knowing whether she wants it, or say something not knowing whether she wants to hear it. Utterly irrelevant. I don't know what he means when he says that stalking was added and yet the statute still has its framework built around domestic abuse. I don't know where we're supposed to go with that. With respect to the credibility issue, when the other side didn't testify at all, they're all in the courtroom, but they never took the stand. None of Erika's descriptions, characterizations, allegations of fact were disputed at all by people who were there and easily able to do it. When opposing counsel suggests that the trial judge must have made a credibility determination here, certainly he can't be talking about the judge saying, well, Erika says this and Alethea says this and I'm going to decide who's more credible. Obviously that didn't happen. What he's suggesting is that the judge just found Erika not credible just by herself. And there is no support for that in the judge's ruling.
Well, a judge can do that, though. I mean,
Say it again?
a judge has the ability to do that. I mean, you don't have to have countervailing evidence. A judge can listen to evidence and just decide, I don't think what you've presented me meets the standard.
Yes. Well, he can certainly decide that a witness standing alone lacks credibility. What I'm suggesting here is that the judge made no such finding. First of all, he said that the respondent's conduct was disgusting, revolting, reprehensible, something like that, I don't recall. He plainly didn't like it. He plainly could see what was going on. And when he explained his ruling, it was on the basis of the application of the statute and the question about distress. He did not comment on Erika's credibility. Thank you.
That concludes the arguments, and your case now has been presented to the court. We have taken this case, and we will render you an opinion in a due course of time. Both parties receive an opinion at the same time and the judgment at the same time. Okay. Then, if there's no further matters to be considered in these cases that have been called, Madam Clerk, I'm going to ask that you please adjourn court until the next calling of the docket.
All rise. This court stands adjourned until May 10th, 2022 at 9:30.
The attorneys may be dismissed.